Well, good afternoon, everybody, and welcome back to the Estate Planning Lawcast. I'm Matt Deliberato from the Deliberato Law Center here in Cleveland, Ohio. And with me today is,
Andrew Jaloza here from the Estate Planning and Elder Law Group in New York City, Queens, New York, to be exact. And this is the Lawcast, Queens to Cleveland, estate planning differences in the two states. And Matt, what are we talking about today?
oh, I can't wait. We're talking about wills. Where there is a
Oh,
will, there is no way out of court. That I have to credit to you, Andrew. I love that saying. Where there is a will, there is no way out of court. That is
and
so
why
true.
is that? What
Well,
do you mean by that?
how many people tell you, Andrew, oh, I'm not worried about probate. I have a will. I mean, can you count on your hands how many times you've heard that? Probably not.
I
And
need your
so,
hand. I need your hands and feet too.
and
Yeah,
plus
everybody's
some, right? Right. Yeah.
right.
And,
Exactly.
it's just interesting because there's so many misconceptions. So we're going to talk about what is a will, why is it important, who's it important for, and we save what really probate court is for another podcast. So we'll just focus on wills. What is it? Tell me, what is a will, Andrew?
No, will's a document, right? You create while you're alive. You name someone called the executor or executrix if it's female. I think at this point, the convention is for most people is just to say executor. I think there's just
Yeah.
one way we describe it. And what that executor is in charge of doing is gathering your assets and then passing them out. So a will is a document that one would use to pass on their assets of what is called their estate to whom they want. And
Okay.
what does that include?
Well, it's interesting because I think it's how you own things, not what you own, right? So what's in a will when you die is anything in your name only. It is not uh, joint accounts, beneficiary accounts. It's what's in your name only. If you don't have a will, by the way, as we all know, the statute, the law tells us who your stuff goes to. Now in Ohio, and I'm sure it's a little different in New York, but it first goes to spouse and kids, and then it's parents, siblings, right? We just keep going down the line until the last beneficiary is the state of Ohio. So if you don't want the state of Ohio, if you're in Ohio to get your stuff, you at least need a will. Andrew.
Well, I totally understand that. It's mostly the same about what you said. So if you have a will, you get to choose who gets what. You still have to deal with a process that's called probate, which we will again go into more detail in the next episode of our podcast. But the bottom line for probate is it is a court process. That will
Yeah.
does not get activated until the executor goes and files it with the court to begin that process of probate. And if you don't have a will, then it goes, as Matt says, in New York as well, under the law of intestacy, which means when you die intestate, it means you died without a will. And then it goes according to the family tree. In New York, it only goes out to second cousins. It does not go as far down the tree as possible. It only goes to second cousins. And how
Hmm.
I found that out is I had a client come and they were a third cousin. And the $3 million in their cousin's estate went to the state of New York because the cutoff is second cousins. So there's
Oh
no
my gosh.
cutoff. There's no cutoff in Ohio.
There, no, it goes to lineal descendants. So if there isn't any, then it'll go to the state. But no, it includes as far as you can go.
Mm-hmm. See,
Yeah.
one
Isn't
of
that
those
interesting?
differences.
Yeah. I would have never thought that. You would think there would be something against that, right? Or at least litigation or something. I don't know. Like, how do you change that law? That's crazy.
It's
I
crazy
can't,
that when you're the third cousin and you think that you've just
right?
hit jackpot and you don't. Yeah.
Yeah, right.
But that's what happens when you leave things up to the law to
Yes.
tell you how things are going to happen, right? That's why that conversation about why it's so important to have at least a will, right?
Oh, it is so important. I had a woman come in the other day, Andrew, and she really knew everything. Like she didn't need me. She had all her own answers to her own questions. And so she talked and talked and talked and then said, "So I don't need a will, right?" And I thought to myself, I'm not even going to begin explaining why a will is important, but yes, it is so important. And I can give you example after example, although in her case, she probably would have said, well, that's not happening to me, or, that doesn't apply to me. But, it is so important. It's imperative. I mean, I don't want the state deciding where my stuff goes. And that's basically why a will is so important. Who is it important for, Andrew?
Well, it's important certainly for anybody, like you said, who wants to make the decisions about who will get their property, how they will get it, when they get it, want to get it. So, like you talked a bit before about owning property, right? So if you have a beneficiary designated for that property, it goes to that person, and it goes outright to that person, directly to them upon the
Uh,
passing of the property owner, right?
that's
If you want
key.
to
Yeah.
make some, yeah, if you want to make some plans, you need to do something like create a will. Because even with administration, right, everything is going to go outright to all the beneficiaries. So if you have a kid that you give $1 to and he spends 10, and you really want to make sure that whatever money you're giving is not squandered, you need to do a will at least in order to create the plan that will his money will go into a trust that will be controlled by somebody else, so he can't just waste it. So
Yeah.
that's important. If it's important to you to make plans for what happens when your family members, loved ones, whomever you're giving it to, it has certain rules, then it's important to do a will. Anything?
Absolutely. I would
Yeah.
say that if I can add on to that a little bit is let's get into the administration, like what happens? Well, there's a bond required. Can you speak to a little bit about a bond or what that means, Andrew?
Well, the court, it does happen quite often in administrations. Usually, when we draft a will, it says no bond will be required for our executor, and that's our wishes. Most of the time, the surrogate, that's the judge that's in charge of surrogate's court, who is the person who makes all the decisions. They will abide by your wishes not to require a bond. But oftentimes in administration, especially if there's a few beneficiaries, what the bond is meant to do is meant to say, okay, Mr. Administrator, Mrs. Administrator, you're going to do your job, but you need to get a bond in case you do your job too well for yourself and you take the property, you do things improperly, that there has to be some protection for the what we call the distributees. That's what you're called in New York when you are you are the heir at law that's entitled because of administration, then you're a distributee.
And it's interesting because in Ohio, I don't know about New York, but in Ohio, they really don't like to appoint executors who live outside the state of Ohio. I'm not sure how New York is, but in Ohio, they will do everything they can, including appointing an attorney, an independent attorney as executor or administrator, I should say, because there's no will usually in that circumstance. That no one lives in the state. Is that true where you're at?
I'm not really. No,
Okay.
that's not really true. Here,
Yeah.
but they may ask for a bond when you're out of state. They
Oh, for sure.
certainly ask for
Yeah.
a bond when they're now it's become very it's become very common that when real estate property is part of the estate, they're now requiring a bond. Almost
Uh,
always in an administration,
wow.
almost always there's going to be a bond, which also
Yeah.
they're going to issue limited letters, right? They're not going to just
Oh,
give
right,
the
right.
administrator the ability to do
Full
anything. They're going to
authority.
give limited letters that you have to come back to the court to get permission to sell property in excess of, say, like $50,000. And any
Wow.
real estate, you have to come back to the court for the court to approve that transaction as well. Do they do
Wow.
that, in Cleveland?
No, no, not at all. In fact, it's interesting. If you have the power to sell real property in the will, the executor can sell no problem. In the administration, it used to be that we'd have to file a land sale complaint, which was a litigation, to figure out if it's okay to sell this property. Well, now they just allow the majority, or I'm sorry, unanimous consent of the beneficiaries will allow that property to sell without
Okay.
anything required. So yeah, a little different there,
Yeah,
but
you
interesting,
see those little nuances too. It's great to understand that everybody doesn't do it exactly the same way. That makes sense. But can you
right?
imagine having to say the majority of those distributees have to agree?
Yes, yes. So it's a great change in the law because the land sale complaint used to cost the client extra money, time, effort, and you'd need weeks to get approval for that. This one you can have people sign a piece of paper and you're ready to go. So
Uh,
it's definitely made things a lot easier.
Yeah, I would imagine that's true. But here we don't even have that. I mean, it's,
Yeah,
the administrators in charge. It's not go does not go by the vote of the distributees, and
right.
ultimately it comes down to a contest, right? It comes down to
Yes,
fighting in front of the surrogate about who's going to whether we do sell, don't sell. And in effect, it's what's called a partition here in New York,
yes,
right?
yes,
So a
right.
partition, you have partition actions in
We
Ohio, I
do.
assume,
Yes, yes.
and that's what is that, man?
Partition action is, in my opinion, I maybe you're better, you're the more kind of real estate knowledge guy than I am, but my understanding of a partition action is just dividing out that interest and making someone or compelling someone to sell.
Yeah,
Um,
yeah. It's same thing. I mean, what happens is two, three, four parties own a property together. Two
yeah,
want to sell, two don't want to sell. You have a deadlock. And what you do is you go into court and you go into the Supreme Court in the case of cases that don't involve estates, and then you file this action for partition. Same thing in surrogates court. It would, technically be that contest about who's going to get what and what are we going to do with the property that would
yeah,
take place in front of the surrogate. And obviously, you can't cut a piece of property necessarily, especially if it's a house. You can't cut it into parts so that everybody gets their part. So generally, they order a judicial sale of the property, and that's what normally happens. And the property then gets sold. So you know, yeah, it is. Part of what we see more and more is like you have family members, the bunch of kids. One's living in the house, the others are not in the house, and what happens when mom and dad die, and who's gonna throw the kid that's in the house out of the house, right?
right,
Well, what were the
right.
wishes? If you don't want them thrown out, you have to have wishes. Put it in your will, right? If you have it in your will, then the court's going to cede to the wishes of the person who died.
No, I can't tell you how many times you just cringe when a family comes in and there's been no planning and you know it's not going to go the way they think it's going to go. And I just had a client come in. He woke up, couldn't get out of bed, tried to get out of bed, fell over. He's learning to walk again, the whole bit. He came into me. He's got 20 properties in his name and some are in joint names with his wife. 3 days ago, they found him dead. And the daughter says to me, and the whole point of the story is to say, well, I know what dad expressed your wishes to you. Is that good enough? I said, no,
Oh
nope, not
boy.
good enough. Sorry, nothing in writing.
Wow.
We got to proceed. So they're in a world of hurt. I mean, this guy waited just a little too long. And that's one thing we don't want you to do is sit back and wait. We do workshops, both of us in our offices, and mine I call proactive estate planning, and that's because you have to be proactive. You have to do something to make sure we have this in place, and a will is your first stop on the train, right? Is a will.
Yeah, you have to have something. Like you said, at this point, property owned jointly with his wife will now belong to the wife, but everything else is a splitting between the kids and the spouse.
Yes, thank God we have good kids and they're all going to sign off, but can you imagine? Absolutely, it's not a good thing,
No, not a good thing, especially when you leave it up to the government and the rules of the government to decide who gets what it is that you have.
right?
Yeah, and what we also find is in those kind of cases, without doing some planning, you often get results that you never expected, like you disinherit your grandchildren or things like that,
Uh,
or you
yeah,
disinherit some of your kids because
yeah.
of the type of planning you've done. I
Right.
have one family came in, and they had three sisters, and they had two of the sisters had children that the grandmother left money for in
Mhm.
their will. But then she had also some trust planning, and she owned the real estate in the trust, and all of her liquid assets, the things that she would have died in her own name, were invested into a property that one of the sisters owned. So now all that property all the liquid assets were in there. The woman passed away. There was no money for the schooling or the things that otherwise that she was passing on to her grandchildren in her will. So, as you said one other time in last podcast, it's not really about the documents. It's really more important what kind of planning you're doing, because
Yeah.
you can have great documents. If the plan's not a good plan, it's not going to work. So effectively, she
Documents.
disinherited her grandchildren.
Yeah. Documents do not work. Plans do. Absolutely. That's
Yep.
a crazy story because I think that that happens in our office all the time. It never ceases to amaze me how many stories we could sit here and tell. It just boggles my mind. One of the things that people ask me is, can you disinherit your spouse? In Ohio, you cannot disinherit your spouse in a will. They have the right to take um, a percentage of the estate. It's usually in Ohio, it's the first 100,000 plus two-thirds of everything else. How about New York? Does that work similarly, or
Oh,
is it?
well, there's a similar rule, that thing we call the right of election. So
Yeah.
if you leave your spouse out of your will, and under administration, your spouse is entitled to get. So that's why it's not protected, quote unquote, under the state law, because they get 50% if there are children. They get
Uh-huh.
100% if there are no children. But when you have a will and you leave your spouse out of it, your spouse is entitled to 1/3 of your estate here in New York. And so the right of election here in New York is 1/3 of the estate of the decedent.
Interesting. Totally
Yeah,
different. Yeah, I
yeah,
would never have thought that.
yeah.
That's really interesting.
In Cleveland, you get a lot more being the
Yeah, right.
disinherited spouse than you do in your New York. And let's
Weird.
talk about spouses, right? How many
Yeah.
people? How many times have people come into your office and say, we have these four kids. Mom and dad were never married, and but they thought they were, treated each other like husband and wife. Now mom is dead, and who owns the house? Is it
Yeah.
dad? Is it the
No.
kids? How would you handle that situation in Cleveland? Two people not married, four kids, a house, not in
Yeah.
both of their names, only in the decedent's name. Who gets the house?
So in Ohio, we have no common law marriage. We do not recognize common law marriage after, I think, 1976. So it's been quite a while. But because they have no legal relationship, it's not his. He has no claim whatsoever, none.
Right,
And so it all goes to the kids. Yeah.
that's right. But even after 40 years of
Yeah.
quote unquote sort of marital bliss,
Right. Right.
nothing.
Right. They should have
Pretty
gotten a piece of paper. They certainly probably argued enough, so they just
right
need
there.
a piece of paper.
Exactly. So no common law marriage here in New York as well. What
Mhm.
about same sex? What about, domestic partners, people who live together and call each other husband and wife? Do you have any certified domestic partner designations?
No, we do not. Do you?
We do, and so what
Oh,
that will
good.
entitle you to is, similar benefits under like the state insurance laws and things
Yeah.
like that. The right to be under your spouse's and your domestic partner's insurance, but it doesn't provide any property rights upon death. So again, you
Yeah, yeah,
need to have something, a will or some other document that's going to legally transfer property to your domestic partner or your
yes.
same-sex partner, right? Two
Oh,
people living
absolutely.
together as husband and husband or wife and wife or husband
Yeah.
and wife and they're the same sex. You got to do planning because there's no
Oh,
rights.
absolutely. None whatsoever. In fact, I had a good friend of mine, and he was living with a guy who, yeah, for all intents and purposes, they were married, but never pulled the plug. And it's the same thing for um every couple out there, if you're not married, you don't have those rights. And so he relied and put money into the house, and now they broke up, but certainly it can cause a lot of animosity and chaos because I think in a lot of those situations, family life may not be great, right? They may not have good relationships with their families sometimes. And that causes even more of a problem, even though this person's been a part of their life for, yeah, 40 plus years. Who knows, right? Uh,
Absolutely.
definitely something we need to focus on and figure out and educate enough to make sure that it's for everyone. Everyone needs to plan.
Everyone does. I had a gentleman come in and he brought this paper that was a will that got produced by a do-it-yourself program.
Mhm.
And it was two gentlemen who lived together for more than 40 years, were not married. And this will purported to leave his condo to his partner of 40 years.
Mhm.
Well, they printed the will out and they did not properly sign it, was not properly subscribed in front of two witnesses, and did not have a self-proving affidavit.
Oh,
And so I was unfortunately the one to be able to tell this gentleman that we have a big problem here. And the fact is, it turned out that that gentleman's second cousin got this condo that was worth $5 million,
oh
and
my
not
God.
the person it was intended to go to.
Oh, how
So
awful.
that's why it's so important to pre-plan, right? If you don't
Oh,
plan in advance, then it really turns into one of our war stories.
yes. Oh my gosh, yes. And so how many times do we have people? I just had a woman come in. She transferred her house to her son. She said, I'm living fine on my Social Security. I just don't want it in my name anymore, etc. I didn't do the transfer because I would have talked her out of it. But anyway, she transfers to her son. Her son opens up a business, and guess what he takes out collateral of? The house. And sure enough, he defaults on the loan, and mom has to move out of her house. It was taken by foreclosure. And I could tell you story after story, but transferring property to your kids during your lifetime is a no-no. Wouldn't you agree?
I very strongly stress that in every conversation I have and every workshop I do. If giving the property away to your children during your lifetime, A, is a potential disaster for tax purposes, and B, a potential disaster for yourself. I've seen a situation where transferred house to the son, and she's ended up living in the daughter-in-law's house, who wouldn't allow her to plant her flowers and garden her garden. And eventually they threw the mother out of the house themselves. It didn't even come down to that. It was, because they got into a lawsuit and the house, there was
Oh,
a
right.
judgment or anything. I mean, they literally threw the woman out of her own house. In
Oh my.
addition to that, think about it though, because people come to me sometimes and say, I think that we're going to do the very simple thing of transferring this deed to my kids. Because they
Mhm.
want to do estate planning,
Right.
but they don't think they need to do much. And they think
Right.
that this is the way we're going to do it because in the old days, that's how they used to do it. Right.
Right. Right. That's the hardest part you come across is, well, mom and dad did this. I don't understand what the problem is, right?
Well, and
And,
here's the
and it,
problem. So you
right.
transfer the house to your son. Your son now owns the remainder of the house. You own and even if you reserve a life estate, say, right, which will
Yep.
help deal with taxation, and we'll talk more about that in the probate issue
Yeah.
of this podcast. But you have the house, you transfer it to your kid, and now he gets into a car accident. He kills somebody. Who are they suing? They're suing your kid. Who owns your house? Your
Right.
kid. What if
Mhm.
your son dies before you? Who
Mhm.
gets the house? His
Yeah.
heirs at law. If he's married and has kids, your daughter-in-law and your grandchildren now own your house,
Yeah.
right?
Scary, right? Pretty scary stuff.
Scary stuff.
Yeah. I remember when transfer on death deeds came out in Ohio, it was in 2000. I just remember that uh like the back of my hand. And we did probably thousands of transfer on death deeds. And now if you come in for a transfer on death deed with me, if you have one child as a beneficiary, I'll do it. Otherwise, we will not do it. And I'll tell you, what's really come down to is the fact that, again, stories, right? We all tell stories, and this is the best story I can tell, is I had a woman who had 6 kids. She transferred on death her deed, so when she died, it went over to 6 kids. Well, they were all married, so we needed 12 people to sign off on this deed because in Ohio we have dower rights, and the wife or spouse has to sign off on property. And so we needed 12 signatures, and one was getting a divorce, and that ex said, I will not sign a thing. And guess where we ended up in?
Wow.
Partition action. And God knows it was probably, tens of thousands of dollars and later that we finally got this house sold. It's such a shame.
Yeah. Pretty
So
amazing.
I will tell you there's good and bad and everything. And it goes to show that you need someone in your corner like Andrew or I to make sure and ensure that you're creating a proper plan. It's so important.
Exactly. And generally speaking, and I'm not speaking out so much against do-it-yourself options, but when you do a do-it-yourself options, you're really not getting the planning in the same way. You're not getting someone who's really going to look into what your family's like, what's going on, who has special needs, what's happening between you, who gets along, what happens, like who are the members, what's going on in your family, and planning for that, right? Making sure that there's a plan with contingencies if something happens first or something happens second, to make sure that you have a well thought out thing that takes all those things into context. And
Right.
and then, because if you don't, number one, you end up in court usually,
Mhm.
and number two, well, even if you have a will, you're going to probate. You want to try to deal with things in a way that's the most comfortable and simple for your family. The thing that will get the most easiest result is to do some planning. Ask someone like us, people who are familiar with all the different aspects, have all the different potential planning tools to give you the outcomes that you want, right? You're looking for a result,
Yeah, and
and we
don't
can
forget.
help you get that result.
Absolutely. And if you're not in New York, or if you're not in Ohio, we can definitely get you to someone that's in our network. We just to make a quick plug, we belong to a national group called Lawyers with Purpose, and it's really what we strive to do is do this planning with purpose. And so if you're out there and you need help, please reach out to one of us, which by the way, you can reach me at info@icanprotect.com. And Andrew,
EPELG.com. Info@EPELG.com. We are the estate planning and elder law group from Queens, New York.
and the Deliberato Law Center in Cleveland, Ohio. Thank you so much,
Awesome.
everybody. We have a wonderful list of topics coming up, and I can't wait. Andrew, thank you so much for today, and we will talk soon.
Thank you, Matt. Have a great day.
Thanks, everybody.